pre-hearing, okay.
Photo is have a self experience of this thing already. This happened with her, with him.
So what would be correct? What would be correct?
So in pre-hearing, I believe he is allowed to have some conversation with both of them because this is pre-hearing. Hearing, he can hire a lawyer, but right now he is.
No, what is the exact issue? I couldn't get.
Scenario is at hearing, not at pre-hearing.
Like when you
for the
come
lawyer.
for hearing, you have to bring a lawyer.
Yes.
Not right now.
At hearing.
No, it's a pre-hearing. It's okay, ma'am. Pre-hearing. Your name is Demo. Your name is Demo. You have a right to counsel. You always call right to counsel only Mr. Gerard. Okay. Now in the hearing, only lawyers. Let's go happen. Only lawyers. Okay. In the hearing, why only lawyers? I can bring my own paralegal. I can bring my own dentist. Anji. Okay. Speak.
No, I understand.
Right? Okay. देखते हैं issue क्या होता है. Keep reading, please. Okay.
Forgot where I was.
Kyoto protest loudly, but to
At the pre-hearing conference.
At the pre-hearing conference.
However, the chair tells Demuth and Kyoto that henceforth it will allow only lawyers to act as counsel at hearings. Kyoto protests loudly, but no avail.
Kyoto protest loudly, but not avail. What you protest loudly? What?
That I want to represent her in the hearing as well.
It means loudly. It means there was a main issue is loudly. This is my real issue. Right to counsel is my real issue.
Why just lawyers?
Why just lawyers? Why not dentist? Why not paralegal? Why not layman person? Okay.
He also alerts the board to effect that on behalf of Demuth, he wants to argue that the provisions of the act that authorize the chair to both direct an investigation and preside at any subsequent hearing are contrary to section 7 and 11D of the Canadian Charter of Rights.
This is a bias question. I'm not going to talk about bias. There was a bias issue. So I'm not going to talk about bias now. Okay.
The chair, with the consent of other two members of the board, tells Kyoto that neither he nor any lawyer appearing for Demuth can make that argument, as the board does not have jurisdiction to entertain charter challenges.
This is not charter. Next one.
At the conclusion of the pre-hearing conference, Demuth and Kyoto approach the senior partner of the law firm at which you are articling and seek his advice on whether they have any basis for challenging by way of judicial review the board's refusal to allow Kyoto to represent Demuth and its ruling that it has no jurisdiction to entertain charter challenges. Thereafter, the senior partner asks you to provide him with a memorandum on those two issues. Prepare that memorandum.
For procedural grounds. We are talking about procedural grounds. So, my friend, what's your name? Raman Bhai. Raman Bhai, we have to pick up the procedural issue. You are Mr. Demo. In the pre-hearing conference, I told you, okay, he is your right to counsel. He was dentist. In the pre-hearing issue, I told you, in the hearing, only lawyers, and you speak louder, but it's not avail anything. Only lawyers is a final decision. Only lawyer. Okay. Now, if you think, okay, what else procedural issue can be? Any notice issue? Can you figure out any notice issue? Okay, any notice issue? No. Any discovery issue? Any delay issue? Any hearing or right to cross-examine issue? Okay, hearing is open or closed? Hearing, no issue, right? Not talking about openness. Not talking about right to cross-examine issue. Not talking about admissibility of evidence. Okay, not talking about a post-hearing issue. Post-hearing issue due to give reason. So what else issue? Apart from right to counsel, can you pick up any issue? Any notice issue, discovery issue, delay issue? You got it? Because he's only one issue. So we have to pick up the issue, maybe two issue. Why he did not? Because we have to solve the exam question. In exam question, What kind of issue do you have? Or right to consult? But you did not mention notice issue. It means requirement met. Discovery requirement met. Delay, no issue. Discover, okay. Right to cross-examine, no issue. Hearing is open, no issue. Just write it on open, no issue. Only issue, what remaining else? What else left?
So, Mr.
Only
Aamer, what about
right to counsel. Now she is very upset. She step out, came to your office. You all people are lawyers. You have to write a memorandum for that nice lady. Judicial review based on the procedural grounds. So before, okay, room number 1. So open room number 1. What is the first step?
Whether decision maker is an admin body.
Whether decision maker is an admin body. What is the name of the decision maker?
Dentist discipline board.
Dentist discipline board is a admin body. Yes. The second step is
Whether applicant have a standing.
no. आप ही बोलो. Only one. You can
Okay.
speak.
Whether applicant have a standing.
Who is applicant?
The person who is directly affected.
What is the name of the person? Right?
Demo.
Demu.
Yeah.
Demu. Yes, Demu was being directly affected by the decision of the admin body. He is being fired from the job.
Hmm.
No one else. Number 3.
Which court did the applicant apply for judicial review?
Federal Court of Appeal. Provincial Court of Appeal. Although this is Alberta, there is no Alberta is a Queen's Bench, but still okay. Provincial. Okay.
Had any deadline lapsed?
Can you see any deadline issue?
No.
No issue. Just write. Have any deadline lapse is equal to no issue.
No issue.
Exact you gonna write in an exam. Have any deadline issue is equal to no issue.
No issue.
There is no issue. Just exact you gonna write in exam. How to solve? We are solving the exam question. Okay. Last one.
I have a question.
Yes.
My question is, looking at the exam
Your
paper.
voice is. Can you pick up the mic? Your voice is very.
Is it better?
Yeah.
Okay, so my question is, looking at the exam paper, you see that they directed us to that particular issue of counsel and jurisdiction. So once they ask that kind of question, directing you to a particular issue, are you supposed to talk about other issues or you face?
My friend, just hold on. Yeah, my friend, excuse me. Yeah, please, I need your. My consultation is totally out. If we can take a break, if you need break, then no, because, just follow me, right? Please. Okay. Say it again, sir, because it's very hard to understand the question. Okay, can you say it again, please?
So my question is, if you look at the exam question, it's directing us to the particular issue of counsel and jurisdiction. So now my question is, if you have that kind of question, do you talk about other issues or you go directly to what has been identified?
No. That's what I'm saying. We have to discuss everything. It's a 50 marks question, man. If you're gonna go directly, only 2 or 3 lines are done. So what do you think? You're gonna get 50 marks out of after writing 2 or 3 lines? No. Start from the room number 1. Just you're gonna say room number 1. That's what I'm saying. How to solve the exam question. I didn't go directly, right?
Yeah.
I'm not going to directly to the specific point. That's why I'm here. How to solve exam question? How to solve? We are right now. We are sitting in the examination hall. After this exam, we are solving the exam question. How are we gonna solve the exam question? Whether decision maker is an admin body? Yes. Alberta Dentistry Board. Number 2 is.
Whether applicant have a standing.
Whether applicant have a standing, it means we have to write in exam. Yes, Mr. Demu has a standing because he was being directly, he would be directly affected by the decision of the admin body. Number 3,
Which court did applicant apply?
which
for
court
judicial
did applicant apply? Provincial Court of Appeal, although it's a Queen's Bench, whatever, right?
review? Yeah. Had any deadline lapsed?
Have any deadline lapse is equal to no issue. How to solve? We are solving the exam question. How we have to write in an examination sheet. Last one.
Has